It's,
You know,
only good for now.
I was like, can you stop doing these things? I'm not doing it.
I didn't. No, shit. No, no. On Saturday.
She's cracked.
I did. Good news about Matt.
Couple more minutes. Just
Yeah.
so like you don't do something.
Okay.
No, I'm not.
You should be in that.
We got it down to 2, like 6 delete. The recommendation Sarah or call.
Which is good.
For Steve, judge.
No, I hear you. Trying to keep that, That's what I'm saying. That's me. Yeah. Just to get and so we can it's just am I good?
Yours.
Well, at least you believe so.
We'll be up.
Thanks, Steve. All right, everybody, good morning. As it is Saturday, we always see a little bit of a decline on this fantastic program, but we know that everyone in this room is going to get a wonderful experience. As you know, we have excellent speakers today, and I can't wait to learn from them. I'm not going to talk any longer than that, other than just to say, please come back in the fall. We will release the list of speakers and dates pretty soon, so you'll get tired of hearing from us in about a month until, I don't know, this time next year, because we'll have a whole bunch of these next year because of Steve's support and guidance and vision. So please come back, tell your friends, bring them with you, and we'll see you in the fall, right? All right, thanks everybody.
All right, so this morning we're going to have Rebecca's closing for the defense. We'll have Nick's rebuttal, some discussion, and at some point after we've had all the arguments, before we have a lot of discussion, I'm going to just take a straw vote to see how many of you think that Nick has met all of those elements that he very carefully outlined, and we'll just see sort of how people think the evidence broke down. Okay.
All right, so good morning. Before I get started, I know I talked a big game about how notes are okay. Just one one thing I will say, I am going to be using notes more than I would in the actual trial because I would have really prepared longer, but had a good job too. So just keep that in mind in terms of what you're seeing. But without further ado, Your Honor, may I proceed? Thank you very much. Good morning. We met yesterday, but my name is Rebecca Weinstein-Dagan, and I represent the people of Energy Dynamics. Energy Dynamics, you heard a little bit about them yesterday from Mr. DiCello, but it is a company, and it's a company that their goal is to make a profit. But it's a company that's made up of people. And I want to introduce you to some of those people. And you heard about them, and you heard from them at trial. M.K. Phillips. M.K. Phelps is Energy Dynamics CEO. She went to NIDA College. She lives in NIDA. She works in NIDA. Her friends and family live here in NIDA. Tony Drummey, Energy Dynamics chemical scientist. He also lives and works here in NIDA. These people who made the decisions about Tetro, they drink the same water, they breathe the same air as all of you. And as you look at the evidence, and as you think about the evidence that Mr. DiCello talked about yesterday, I urge you to focus on the actions of the people. What are the actual actions? Not what do us talking heads say, but what does the evidence actually show that the people did? Because Ms. Phelps and Mr. Drummey acted in ways that people act when they believe in their product, that they believe that what they did was right, and they believe that their product was safe. What do I mean by that? I'm going to give you one example. In March of 2025, Ms. Phelps and Mr. Drummey attended a town hall meeting here in NIDA. And at that town hall meeting, anybody could ask them any question that they wanted about Tetro. And we have a transcript, and you heard it at the trial, but here's one of the things that Ms. Phelps said at that town hall meeting. She said, "We have a review process in place. We make sure we're doing our job. Don't forget, if we screw up, the DNR, that's the Department of Natural Resources, is all over us. Nothing makes me madder than cutting a check to them, because not only is it embarrassing, but it's costly. We work real hard to prevent leaks or pool contaminants from escaping. We'll keep working hard for you." Now, that tells you two things. It tells you that they're trying to do the right thing. It also tells you that, yeah, they have a financial incentive to do the right thing, because if they don't, that hits their bottom line. Now, when I said that they believe in their product and that this is evidence, they showed up to this town hall meeting, no lawyers, no PR people, just Ms. Phelps and Mr. Drummey answering questions from the community about their product. And you need to think about whether people who are hiding some secret act in that way. Now, nobody, including my client, is happy about what happened to Mr. McNamara's cows. It's tragic and it's sad. But your job today isn't to decide who deserves your sympathy, because you know what? Mr. McNamara does deserve your sympathy. But that's not why you're here today. Your job is to decide, based on the actual evidence, whether Mr. McNamara proved, because it's his burden of proof, that Energy Dynamics acted negligently, that negligence actually caused harm to his cows, or if Mr. McNamara's cows got sick and died for other reasons. Now, the problem is that Mr. McNamara's entire theory is a chain of speculation. And the chain of speculation goes something like this. Tetro exists. It shares some properties with benzene and arsenic. We had a waste pit that wasn't perfect in 2021, and we got a citation for that waste pit. And that means that over in 2024 and 2025, Tetro hurt Mr. McNamara's cows. But that chain of speculation isn't proof. And our judicial system does not let you decide a case based on sympathy and speculation. Your role as jurors is to decide based on the evidence. So now I want to turn to what the evidence actually showed in this case. The evidence actually showed three things, and we're going to go through each of them. One, the energy dynamics acted reasonably and Tetro is safe. Two, that Tetro did not cause the cow's illness or death. And three, that Mr. McNamara did not act reasonably. So let's take them each in kind. Energy dynamics acted reasonably, Tetro is safe. Well, the Tetro is safe part, you don't have to take my word for it. This is not a lawyer argument. What we know from the evidence is that the Department of Natural Resources tested the well site 3 times. Tested the water, not lawyers, the Department of Natural Resources. And those tests showed every single time that the water was safe. Now, one of those tests was before Tetro was put on the market, but the other 2 happened after Tetro was on the market. 3 tests, 3 clean results, every single time. Tetro is safe. Now, the other part of what the evidence showed was that energy dynamics acted reasonably. One of the things that a company like Energy Dynamics has to do is they have to test their product. And Energy Dynamics did test its product. And you heard a little bit of that from Mr. DiCello yesterday, but there were some things that he left out about that testing. I want to talk about that testing for a second. Matt Barron, one of the chemists from Energy Dynamics, he was part of the testing of Tetro before it was put on the market. And over the course of 16 weeks, this is from his report, it's an internal report. Over the course of 16 weeks, he exposed each group of animals to a controlled amount of Tetro. As a control amount, we used 500 parts per million. Now, what happened when Mr. Barrett exposed the animals over 16 weeks to 500 parts per million of Tetro? They got sick. And you saw that slide from Mr. DiCello again and again yesterday. The slide showing you that the animals had seizures and they died and spasms. And he wants you to believe that that's evidence that Tetro caused harm to the cows. Well, what he didn't explain to you yesterday was what is 500 parts per million that these animals were exposed to. And now I've got to walk through some things here. The government, the Department of Natural Resources, says that benzene, which shares properties with Tetro, is allowed up to 5 parts per billion, not million, 5 parts per billion in the water. The government does not say you can't have any benzene. They know that's not realistic. They say you can have it, but it can only go up to 5 parts per billion. And the testing, there were 3 tests, but I took the highest reading from the test. One test showed a reading of 4 parts per billion of benzene. Now that's okay. 4 parts per billion of benzene. But Mr. Barron is testing it on animals over 16 weeks, giving them again and again 500 parts per million. The difference between those is 250,000 times. Now, I tried to think of a way to explain this because there's a reason I went into law and not into science or math. 500 parts per million, 4 parts per billion, it wasn't 100% clear to me right away. Like, okay, what's the big deal? So here's an analogy I came up with. The FDA has said that it is safe, and the tests have shown it's safe to take aspirin, 2 aspirin for a headache. That's okay. And the analogy is the same as it's okay, the government has said, to have 4 parts per billion of benzene in the water. But what Matt Barron did when he exposed the animals over 16 weeks to 500 parts per million, that's the same as taking 250,000 aspirin. Of course, 250,000 aspirin will kill a person if they took it. But if somebody gets sick from taking 250,000 aspirin, that doesn't make aspirin dangerous. And it's the same here. Just like exposing animals to 500 parts per million of tetro and seeing them get sick, that tells you absolutely zero about what actually happened at the well site and whether those cows got sick from tetro. Matt Barron created a laboratory test that was sure to kill animals, but that test has nothing to do with what actually happened at the well site. Now I want to talk a little bit about some of the witnesses in this case, because one of the things that you get to do as jurors is you get to assess their credibility and you get to assess their motivations. Who is Matt Barron? Matt Barron was a chemist at Energy Dynamics, and he worked on the tetro testing, and he disagreed with the company. And that's fine. Scientists disagree. But Matt Barron didn't write a formal complaint. He didn't file anything with the government saying, hey, you need to look at this. Instead, he got into a physical altercation with Tony Drummey. He shoved him. He knocked over a bunch of expensive equipment. And as a result, understandably, he was suspended. Well, he decided then to quit Energy Dynamics. And when he did, he started a blog. And the blog was talking about the things that you heard from Mr. DiCello, the accusations, the allegations. And then he went to work for Green Fellows, and it's an advocacy group whose entire mission is to go after companies like Energy Dynamics. And he started a Facebook campaign. On the Facebook campaign, he called Energy Dynamics criminals, and the people in Energy Dynamics criminals, and you saw that evidence in the trial. And then he showed up at the town hall, and he made a scene. Matt Barron is not a neutral scientist presenting objective findings. Matt Barron is a man with a mission and a grudge. Energy Dynamics acted reasonably, tetro is safe, and they have not proved otherwise. Now let's get to the next point. Tetro did not cause the cow's illness or death. Remember I talked to you about that chain of speculation that Mr. DiCello has? Well, that chain of speculation starts with the citation that we got in 2021 that our pit was not up to standards. And they were right. It wasn't. I saw the picture the same as you. I'm not going to hide from that. That pit was not as it should have been in 2021. And you know what we did? Prior to tetro coming onto the market in 2023, we fixed the pit. And the government came back and said, okay, you're good. We fixed that pit. Second, there were 3 clean water tests after that pit citation and after we fixed the pit. 3 clean water tests. That citation is not proof of anything related to Mr. McNamara and his cows. Speculation. Sympathy and speculation. Tetro didn't cause the cow's illness or death. I was lucky enough, my mom grew up on a dairy farm, I was lucky enough to spend every single summer on my grandparents' dairy farm in the Pacific Northwest in a little town called Centralia. And I can tell you that cattle die. It's a fact of farming. From calving, from heat, there's a whole bunch of reasons that cows die every year. Now, Mr. McNamara had 200 cows, but he has no idea how many cows died from just those natural processes every year. And don't take my word for it, this was his testimony. Question, let's focus on the old reservation farm. How many cows? Answer, it's large. We have 200 head of cattle. Question, how many cows die every year just from natural causes? Answer, I have no idea. Maybe a handful? Question, you have no idea? Answer, well, I'm the CEO. I don't run around the country counting heads of cows. That's not really my problem. It is his problem for this case. Because if you don't have a baseline, if he doesn't know how many cows die each year under natural causes, how can he prove that 25 in a year is abnormal? Without a baseline, there's no way to know whether anything unusual happened at all. Because it's a fact of life that cows die every year. But it's also a fact of life that cows die and get sick at even higher rates when they aren't being cared for properly. Mr. McNamara did not care properly for his cows. Now, again, I want to talk about and introduce you a little bit more to Sean McNamara. You didn't hear much about him yesterday and kind of his background. Mr. McNamara is a finance guy. He's not a farmer. This is not a man who grew up on a farm with a passion for cattle. And you can see that again from his actions. When Energy Dynamics first started drilling next to him, he sent a text to MK Phelps. And his text was, how am I supposed to get bed and breakfast guests when they have to look at this? It wasn't about his cows, it wasn't about the water, it was about his bed and breakfast guests. And that makes sense. Again, he's a finance guy, not a farmer. He spent 3 years on Wall Street before he got investigated for insider trading and left that job. He has $50 million of loans still on his many properties, including this farm. He has walnut farms, he has cranberry bogs, he has a whole lot of businesses, and they are all under tremendous financial pressure. So that's Sean McNamara, finance, not farming. Now let's talk about how he did care for his cows. Again, you have to judge his actions. About 15 to 12 years ago, there was an undercover documentary team that did a piece on his farm, and he was asked about this at trial. They sent in this kind of undercover crew to film our workers. Question, what did they find? Well, they saw many of our employees hitting the cows, being a bit rough. It was a PR nightmare. Well, about 15 to 12 years ago, the organic food movement was really getting off the ground. We wanted to get in on the ground floor as a way of expanding and as a way of purging the taint of that ridiculous documentary. Question, why was it ridiculous? Answer, because they're cows. They're not people. They weigh thousands of pounds. They're stubborn. You don't have to treat them like they're toddlers. That's 15 to 12 years ago. Let's fast forward to May 2022. May 2022 is before Tetro is on the market. May 2022, Dr. Santo, the veterinarian in Nita, comes to his farm because his cows were experiencing spasms, lethargy, they were tired, irregular bowel movements, so they were having GI problems, and other troublesome symptoms. And Dr. Santo was so concerned by what he saw that he filed a complaint with the Bureau of Animal Welfare. And he said, I found the animals to be living in tight quarters, in tie stall pens not consistent with animal health, and certainly not consistent with organic farming standards. Yesterday, you heard they had bad people working, but he fired all of them. It wasn't just the people, it was the conditions that he had them in. And he found that they had lesions on their sides, as if the animals had been struck by their handlers. Why does this matter? Why am I talking to you about May of 2022? Let's fast forward to the fall of 2024. Dr. Santo is back on Mr. McNamara's farm. What does Dr. Santo find? Spasms. 2024 spasms, 2022 spasms. Tired, lethargy. 2022, 2024. Gastrointestinal issues, GI problems. 2022 and 2024, the same exact issues. But this time, Mr. McNamara had Energy Dynamics to blame. The evidence, though, does not show that Tetro caused these cows' illnesses. Bless you. Instead, what does the evidence show? The evidence shows that Mr. McNamara did not act reasonably. Mr. McNamara was negligent. This is evidence right there. How's Mr. McNamara treating his cows? What's the actual evidence? Now, we do not think that they have carried the burden of proof to show that Tetro caused any issues. But if you found that Tetro played a role in the cow's illness, even if it had been Tetro, Mr. McNamara still had to do what he needed to do to keep his cows safe. And what does the evidence show about that? First, from his own complaint, this is from Mr. McNamara's complaint, this is not an energy dynamics document. He says, on about April 12th, 2024, plaintiff noticed his cattle and dairy cows exhibiting strange physical symptoms. April 2024. Dr. Santo, this is from Dr. Santo's report. Dr. Santo says, in the summer of 2024, Mr. McNamara, says his handlers complained over the summer of symptoms, but he thought no prob. But Dr. Santo told him to restrict water. Dr. Santo was concerned and thought maybe it's the water, I don't know for sure, but hey, don't let them go to the stream. What happens next? August 2025, his cows start dying. It wasn't until the spring of 2025 that Mr. McNamara finally stopped letting the cows use the reservation stream. About a year from the time that he saw his cows having symptoms, from the summer when Dr. Santo said, hey, don't know what's going on here, but maybe don't let them use the stream, it wasn't until the fall of 2025 that he finally stopped having his cows drink the water. Now, if he really thought it was the drinking water, didn't he have a number of things that he could have done? He could have had his cows stop using the stream. He did it eventually. He could have called Energy Dynamics and said, hey, what the heck? I think that there's something wrong with your stream. And you know what? Eventually he did call Energy Dynamics. And what did they do? Again, you heard from MK Phelps. She said, she was asked, after McNamara told you about the cows, what did you do? Answer, we kept testing Tetro to make sure it was safe and ordered the polytyrene or ethylene lining of the pit to be replaced strictly as a precaution. I did it as a good faith gesture. Energy Dynamics acted right away. And by the way, this evidence in the trial, we heard but Energy Dynamics tested one time. They kept testing. Again, he could have called Energy Dynamics. He didn't do that. He could have asked the Department of Natural Resources to investigate. He didn't do that. And here's what makes that decision not to act especially hard to understand. Because the state of NEDA has a statute. And it says that if you are concerned about a drilling operation, if you're an owner and you're concerned about your neighbor drilling operation, you can ask the Department of Natural Resources to investigate. And I know sometimes government bodies aren't all that fast, but this statute tells the Department of Natural Resources that they have to act within 10 days of receipt of the investigation request. They have to investigate that claim. 10 days. But Mr. McNamara didn't make that call. If he had, the government would have tested the stream, and we would have that evidence here today, but we don't have it. And that's not on Energy Dynamics. It's Mr. McNamara's burden of proof, and it was Mr. McNamara's responsibility to act reasonably with his cows, and he chose not to. Look at his actions. Now, Mr. McNamara's actions tells you one of two things. Either, number one, he didn't actually believe the water was the problem, which undercuts his entire case. That's number one. Or number two, he was so careless with his own animals that he bears enormous responsibility for what happened to them. Mr. McNamara did not act reasonably. Now, the judge will tell you that for Mr. McNamara to prevail, he has to prove that energy dynamics was negligent, that negligence caused the harm, and that there was harm, and that negligence actually caused the harm. But the only person who says that Tetro is not safe is Matt Barron, using a test that was designed, there was no way those animals weren't going to get sick and die from that test. And on the other side, we have in the record the evidence that Energy Dynamics has one citation that we responded to and a series of clean well tests. That's the evidence. So when you get the verdict form, you're asked, was Energy Dynamics negligent? I'll submit that the answer is no. And when you're asked, was defendant Energy Dynamics negligence a substantial factor in causing harm to the plaintiff? Again, the answer is no. And even if you were to find that Energy Dynamics was somehow negligent, Mr. McNamara's negligence contributed to the harm. Mr. DiCello read you this instruction yesterday too, and we agree that this is a very important instruction. Negligence is the failure to use reasonable care to prevent harm to oneself or to others. A person can be negligent by acting or by failing to act. Acting or failing to act. Remember this timeline. Acting or failing to act. Acting. No testing, no reporting, no action. That's negligence. Ask yourself whether Mr. McNamara's actions were those of a reasonable farmer. I will submit that they are not, and that Mr. McNamara was negligent, and his negligence was a substantial factor in causing harm to the cows. I'm getting close to wrapping up. I want to talk to you about a couple other things. One, Energy Dynamics has 1,000 wells in 6 states. And Tetro has been in the market since 2023. If this chemical was a catastrophic poison, you wouldn't have one complaint.
Objection, Your Honor. Matters that are unrelated.
Counsel, has there been evidence in this trial about
Texas and New York?
You're fair, Your Honor.
All right,
All right,
I
I'll
was
move
sustain the objection. The jury's to disregard that last comment. Those are facts, not in evidence.
Fair. Thank you, Your Honor.
This case involves what happened in Nita with Mr. McNamara's cows.
Fair. And you have Sean McNamara. Sean McNamara, whose businesses are struggling. Sean McNamara, who has mounting debt. He's losing tourists. Sean McNamara, who looked around and he saw his neighbor a deep pocket, and he made a business decision. And this lawsuit is that business decision. Now, this was my one chance to talk to you about evidence. The way that our system works is, because it's the plaintiff's burden of proof, Mr. DiCello got to talk first, and he gets to talk last. And I say that because no matter what Mr. DiCello says when he gets up, no matter what he says about my client or about the evidence, I don't get to stand up and respond to him. So what I ask of you is, while you're listening to Mr. DiCello, that you think to yourself what I might be asking you to think about. Why were the cows sick in 2002 with the exact same symptoms. Why didn't they tell you about how that testing was done and that it was testing that is nowhere close to what would happen and did happen at the actual well site? Why did Mr. McNamara wait so long to act, almost a year, if he really thought that it was the water? Why is Mr. McNamara doing energy dynamics? And what does the evidence show? Not speculation, not a chain of speculation from 2021, picture of a pit from 2021 until today. On behalf of Energy Dynamics, I thank you very much for the time that you're taking, both to listen to the evidence and back in the deliberation room. As you can tell, this case is important to both parties, and I know that I can speak for Mr. DiCello. We both thank you very much for your service. Thank you.
Thank you, Ms. Macon. We'll now have rebuttal closing from Mr. DiCello.
Thank you, Your Honor. May I have a moment to set up my...
Sure.
Thank you. Can I proceed, Your Honor?
Hey.
Good morning. It is my last chance to speak with you. I appreciate your patience. I just want to highlight a couple of things that we heard from Energy Dynamics lawyer. I was listening along with you, and I think I heard this, that Energy Dynamics Corporation's chief chemical engineer, to try to evaluate the safety of a breakthrough chemical they just invented, designed a test to kill the animals. What information would a corporation get if the test is designed to kill the animals? You have the testing, and I know ED would like to distance itself from its own chief chemical engineer. I understand why they want to distance themselves from his scientific conclusions. This is the testing report, and you'll have it. And when you review it, read it and see. You know, I think this looks like something that was designed for the purpose of killing the animals. What purpose would that serve? What information would Energy Dynamics have but for to then get up in a courtroom like this and tell you, don't look at the testing, it was designed to kill all the animals. I'd like to see some testing where they wanted to evaluate, will it kill the animals? What will it do to the animals? That's what chemical engineers who deal in toxins seek to test. And I'm getting granular here, but take a close look. This says the amounts that were used. And you have to remember, this is a corporation that blasts chemicals thousands and thousands of feet into the ground to fracture the earth, literally, and free up the gas. And then water and sand and arsenic and benzene comes squirting back out of these deep holes, and they have to contain it. One risk is that these chemicals leak into the aquifer when you're underground. That's a risk. But the other risk is when you dump this stuff by bucket load and truckload into a pit that you've dug out. It's just sitting there, and it can escape from that source. So when counsel was talking to you about parts per billion and parts per billion and how much aspirin somebody would take, 250,000 aspirin, if I followed that, look at the report. And what does the chief's chemical engineer from this corporation talk about? It says these results came from concentrated exposure to tetro. Levels comparable to 500 parts per million are very unlikely to occur in natural circumstances. That having said, these results are alarming. And when he looked at 500 parts per million, he said that was the highest level, here it is, I'm sorry, as a control amount we used 500 parts per million, which exceeded the tetro loss in well 2. That's the loss into the aquifer when they blasted into the ground. Then what did he say? The highest level of the test wells. In other words, we use the worst case scenario for exposure through lost chemicals to an aquifer or subterraneous water sources. This is critical, but not necessarily the worst case scenario for spillage from wastewater storage pits. So this corporation's own test at 500 parts per million isn't the worst case scenario. Sean McNamara is not claiming that the chemicals they blasted into the ground leaked underground. He's claiming that there was spillage and leakage from this site, which we heard about as well. And we heard, this is what I heard, we heard the corporate CEO, we have a review process in place. What is that review process? We saw the evidence, do more testing. They haven't been able to produce any testing. Their testimony from the CEO, yeah, we kept testing it. Where is the testing? I won't show you my slide. There's no testing in here from 2024, 2025, or 2026. No testing was done. So what's the review process? The review process are these site inspections that were shown. Not their own review process, the government's review process. When they come by and make surprise visits. We know what happened on the one visit when they saw this site. There was inexcusable code violations. A dead bird. Kids had access to the site. It's dug out 20 yards away from a stream. So we know February of 2023, this is before tetro's being used. And then there's only 2 more site investigations in evidence. One of them is from August of 2023. Remember, tetro didn't start being introduced until June. Don't even know whether tetro was being used. So what is their review process? This corporation's review process is there was one inspection. One inspector came by once and didn't write anything. And what was he testing for? Not tetro. Remember, can't test for tetro because this corporation won't tell us what's in it. So we can't test for it. What she didn't, what my colleague on the other side did not mention is the inspector who performed that inspection was fired. Why? Because he consistently failed to issue citations properly for natural gas operators. He demonstrated blatant favoritism to these corporations, and he's now working in the industry alongside Energy Dynamics. That's the review process. One site inspection that doesn't test for tetro from an inspector who was fired for showing favoritism and not issuing citations. They're asking you to evaluate their actions of a reasonable company. That's the review process that we just heard about. Chain of speculation. We talk on that one moment, and then I'll finish up with you with one more point. Chain of speculation is what we just heard. Look at the evidence. What happened to these cows? There's only one doctor who's evaluated these cows. Dr. Santo. Those medical reports are in evidence. Those medical reports describe the problems with the cows. Nowhere in these medical reports is there any suggestion that these epidemic portion signs and symptoms and problems are from abuse. The doctor came by and saw some things he didn't like, reported it. Sean McNamara doesn't argue with his observations. He may disagree with them, but he's not arguing with them. It was reported, and Sean McNamara dealt with it. But that same doctor came back to this site, and he evaluated these animals. And what did he say? You'll have the evidence. What does the doctor in the case think is going on? He thinks it's arsenic, benzene, or some kind of petroleum product. Nowhere in any of these reports does it say abuse. If the doctor thought that was even a possibility, he could have wrote it down. We know he's written it down in letters in the past, and he didn't. There's no evidence that he said, hey, Sean, I think the problems here on this farm are because of abuse. So that's not evidence in the case. That's speculation. And I just want to say on your behalf, Mr. McNamara, Sean McNamara grew up on that farm. He grew up on the McNamara farm. He takes issue with this company saying he ain't not a farmer. Sean McNamara grew up on that farm. And so what did we hear? Tetro is safe. Even to this day, folks, this corporation could not acknowledge, will not acknowledge that this chemical is dangerous. It's a toxin. It's a poison. It's a byproduct of fracking. It's more dangerous than arsenic. To believe this corporation, when they say Tetro is safe, you'd have to think that arsenic is safe. Benzene is safe. Not just a little bit of benzene, like we heard. A little bit of benzene, that's okay. Arsenic is safe. Benzene is safe. And therefore, Tetro is safe. Because we know Tetro is more dangerous than both of those chemicals. It's okay. It's okay to produce dangerous chemicals, but you have to be responsible. You have to be honest with the community about the dangers associated with these. I won't go through the evidence, but you have the reports. You have the reports that say, word for word, not my words, the corporation's chemist's words, Tetro is dangerous. And yet here we are in this courtroom, and some of the last words you heard from this corporation is, Tetro is not dangerous. Remember when I said they need to be honest, not just with us, but with themselves. And that brings me to those of you who were here, you remember when Ms. Phelps testified and my colleague was cross-examining her and they were talking about whether Tetro was safe. You might remember if he said, what if I put some Tetro in your coffee cup? Remember, she couldn't even look at the cup. Did you drink it? You remember, none of us would drink it. Neither would she. Drink. Toxic byproduct of hydraulic fracking. They fixed the pit. We heard that. We fixed the pit. There's no concrete basin in that pit, folks. And we know the evidence, despite not further testing, is that Tetro will get through all but the most impermeable liner. What kind of liners did we use? They used, the only evidence is they used the lowest quality, the cheapest ones. Should have been concrete and liner. No concrete in that basin. They want to put the onus on Sean to test for their deadly chemical without telling us how to test for it or what it is. Won't tell Nita what's in it. That's their trade secret. It's not in the water. Trust us. And even if it is, it's not dangerous anyway. But it was Sean's fault for letting them drink the water. How does it all work, folks? Sean's negligent for letting his cows drink out of the stream that didn't have Tetro in it, and even if it was in there, it's not dangerous. Shifting sands to avoid liability. That brings me to my final point. I appreciate your patience. I've had the privilege of representing Sean McNamara, a farmer from this community, who grew up on his farm, the McNamara farm. We talked about that in Vorvier. A lot of people know the McNamara farm in this community. Sean grew up on that farm. His father worked that farm. Sean's a farmer. And it's been my privilege to represent Sean in the McNamara farm. I've had the job and the burden of representing him and his farm in this case for the past 2 years. This part of the case is always the hardest for me because my job now is over. There's nothing more I can do. I'm sure I could have done better. I have to turn the case over to you. And the power of an American jury is magical. None of you met before we started this trial. We were all brought together for this single purpose, and you'll probably all never be together again, unless you have a jury reunion or something, but you'll probably never all be together again. Probably never have the opportunity to do what you're about to do ever again. Most people never get the opportunity that you have. I've never been on a jury. I've never had the power to decide. So what power do you have? This corporation will not take responsibility. Maybe they just can't. They can't let themselves believe what the evidence is. I can't make them take responsibility. His Honor can't force Energy Dynamics to take responsibility. You have that power. Awesome power. So on behalf of my client, on behalf of Sean McNamara, we ask that you return a verdict in the amount of $1.75 million. Trust that you are the right people to make this decision. All of us in this courtroom, I know I speak for all of us, we trust you. Thank you.
All right, well, I think both of our experienced lawyers gave great closings. So I think before we open it up, well, why don't we have a show of hands? How many feel that the plaintiff has met its burden to show negligence and that the negligence was a substantial factor? Certainly, I think, whether the jurisdiction negligence, yeah, Nick can't vote, Rebecca can't vote. How many people feel the plaintiff has met its burden? 10. All right. How many feel the plaintiff has not met its burden?
Very good.
Yeah. Well, spoke like a true defense.
Yeah, exactly.
Sometimes a hung jury is good, as we were discussing, because I think statistically, a retrial always favors the defense, because the plaintiff, whether it's civil case or when I was a prosecutor, you can't change your case too much. The witnesses are the witnesses. The documents are the documents. Your theory is your theory. All the defense has to do is poke holes, and you've seen everything that the plaintiff has, and you didn't poke holes the first time. Trust me, after poring over it for a number of months, you'll find a few more, and so you have an edge the second time. So a hung jury's victory for the defense. So.
I'll also say another thing about hung jury. Sometimes most cases settle. I agree. I would have often or went to trial, but often they don't settle because one or both sides are being unreasonable. And a hung jury, I had a judge. I had a hung jury in a case that went on for a really long time. The judge brought us back, the lawyers back, and said, "I'm telling you guys both right now, the jury didn't like either of your cases. So go back and think about that, and I'll tell you what, that case settled the next week." So a hung jury sometimes also gives some information for both sides.
Because it points out neither side, the case was as strong as they thought it was. And okay.
I just want to show one thing before we get started with questions. If I'm able to do the presentation. As you demonstratives are a big thing that we think about all the time, and I tried to show a little bit of, we like to do kind of low tech graphics, higher tech graphics. But one of the things I wanted to show you is graphics take a long time to think about and to get right. And I didn't have as much time as I wanted to on this, but I wanted to show you some of the sausage making in that, we came up with the graphics that we ended up showing you, but there's a lot that ends up on the cutting room floor, and I'm sorry that, I hope this doesn't get spasms. So, and Jackie and I were working on this and constantly trying to think about, oh, so this is immersion propaganda. But we always have what we call a parking lot or bin slides. So we thought about different ways. You know, I thought about, do I do what we need to prove on a PowerPoint? And I decided, no, I want to put it up. And by the way, you know, this wouldn't have happened in an actual trial because Nick would have not let it happen. But you know, this was up the whole time he was still speaking, and I love nothing more than when the plaintiffs forget that my demonstrative is up there.
The judge is not going to.
The judge is not.
No. Right? If you left it up, you left it up.
No, and like both, it's a war on both sides. They're always trying to leave their stuff up. We're always trying to leave our stuff up. But you know, try it. You know, this was one of the things we thought about in terms of the water. Like, do we do it this way? We thought it was too messy this way. We went through a whole thing about the fact that Tetra was never tested. That goes both ways. We ultimately, Jackie and I decided that actually is bad for us. For a while we were using it affirmatively, so we left that one out. Again, just kind of a different version. We call these Gotti charts. You should look it up. I'm not going to explain, but they started in the trial of John Gotti. The government had, anyway, Gotti chart, look it up. It's very fascinating. The dose gap, we tried, okay, do we do the difference between what it looks like if you have a little bit of coloring in water? What about if we show the difference between a drop in a bucket or a pool? Then we had a Syrah example, like what's 1 dots versus 220,000 dots? You know, what does that look like? 1 billion dots is all these Syrah paintings. So the point is, one, you got to be ready to throw away your ideas that you think are good and you get very invested, and then your paralegal tells you it was a bad idea. But just that it takes a lot of time, and good demonstratives take a really long time, so don't underestimate.
I thought the 250,000 aspirin was great.
Did you? Great.
Because anyone's going to, you're not going to get lost with that. And anyone knows you take 250,000 aspirin, you'll die.
Yeah.
Okay? So,
but you also got to think, because this also does happen, like we do a lot high-tech, low-tech, but you know, Nick, I think he could have had a real advantage also with being a little bit more low-tech, doing things on the fly. So you got to just think about all those things. But jurors, talking at them, you know, biology, there's a lot of science on visual and how that impacts you versus oral.
Can I make one comment before the question, just to follow up on her point? The reason I really moved towards this document camera is the flexibility it gives you. And her graphics were great. They were professional. They were clean. They were still simple and easy to understand, and they were compelling. But what I have found is, if after a 2-week trial, a 3-week trial, and the jury gets in this habit of just something pops up on the screen, somebody in the back room is popping something up on the screen, you know, there is a lot of value in a courtroom to be able to walk over and pick up a document and walk across and say, let's remember what it says. Let's all take a look together and put it on the screen and pull it up and point it and have it in your hands. And that's lost, I think, in a lot of the way that modern trials are done, with a team of people presenting everything. And can you pull up the medical record? Or, you know, I like having, if there's a medical guidelines or a book involved, you know, this is the treatise, and they pull it up and show it on the screen. That's great. I like having the stack. And sometimes, you know, I'll just have it next to me, you know, and you're cross-examining an expert, and sometimes you get to the point where all you got to do is just point to the book, and the expert might know not to go there. Well, remember, doctor, we looked in the book. And so that's a point I would make, that the document camera has freed me up from, well, if it's not loaded in the computer and somebody can bring it up on the screen, I can't really use it. So 2 ends of the spectrum, and I think a good trial and a good trial lawyer will use everything. Because the other thing is, we're trying not to bore these people to death. You know, they've been sitting there staring at the screen for a week or 2 weeks or sometimes a month long. And I think the document camera frees you up to do those kind of things in the courtroom, and they can be really powerful, and it's very low tech.
the advantage of that is those documents are in evidence. The slick fancy charts won't be. So the jury's not going to be able to go back and look at those charts. They can go back and.
I'll also tell a hybrid of that, and this is a bit of a secret, and I'm always fascinated that lawyers don't do this. So We all, at our firm, run our own trial software. So you go into trial, you see a lot of lawyers, and they do what Nick was just saying. Hey, there's usually a guy sitting over there, they call him, he's on the hot seat. Hey Dave, can you pull up XYZ? Hey, can you do this? We don't do that. I operate my own trial software, I pull up my own documents, I highlight my own documents, and let me tell you, it's super freaking easy, and lawyers just don't do it. So, and the jurors they think a world of difference, and it's often also on the plaintiff side that they're having Dave in the hot seat do it, and the jurors are like, oh, she knows how to do it, she can pull up, and you get more credibility, and I'm telling you, the software is so easy to use, but so many lawyers don't use it, and so, Nick, there's a secret that now you can go use it.
Yeah, no, we do all our own as well. My partner has kind of forced me to adopt this and get proficient at it. That PowerPoint, I was telling folks yesterday, that's the first, Friday afternoon or Thursday afternoon was the first time I logged on to Canva and tried to create a presentation, and I was able to put that together. I'd never used it before. I watched my partner do it. But I agree, when they see the lawyer being able to do it, and even if you fumble with it a little bit, they understand. Some people are afraid of technology on the jury, and they might fumble with something. They don't hold that against you as long as you're being efficient. And I also, as the plaintiff, I want to have as few people on my side as possible. I want to look like I'm up against
David versus Goliath.
Exactly. And when you've got a team of people running your presentation, it interferes with that dynamic. I'm sorry, I cut you off. There was a question over there?
No, you all just answered it actually.
Okay,
So.
all right. So we have one here.
In your opinion, I noticed that you pushed the envelope, and which may have garnered an objection. Is it better in your mind, and I know it depends on the case, to push that envelope or to play it safe, knowing to play it safe for a jury trial? And if you could compare it to a bench trial.
Can I ask you one question? I have my own opinions about when he pushed the envelope, but where did you think he pushed the envelope?
I didn't think he pushed the envelope.
Oh, you're talking about me. I pushed the envelope.
Yes.
In the 1,000 wells.
Right.
Oh, I mean, first of all, almost invariably now, your demonstratives are approved. The parties talk about them ahead of time, so he would have already objected, the judge would have ruled on it, that would have happened. I would never have pushed the envelope in that way in an actual trial, talking about other complaints. But you know what, it was for demonstration purposes, so, for education.
What I would say is you have to feel your way through every trial, the judge, and think about that on your feet. I think Rebecca and I are of the same mind that we rarely object. We just don't, because the jurors want to hear the story. And if I object, one, I could get overruled and then I've just wasted everybody's time. Or if it's sustained, sometimes the jurors are looking in there, they have animosity towards me. Like, what does Nick not want us to know? What does he not want us to hear? Why is he getting in the way? My threshold for objecting is very, very high. And if I have a doubt, I want to sit there and not object. I want the jury to appear as though I'm bulletproof. I don't care what they say or what they do or what evidence they bring in. So my threshold for objecting is usually very high, and rarely do it. And I think Rebecca, just talking with her, I think she's of the same mind that, generally speaking, don't make a lot of objections. Certainly not during a close. I mean, that was rare that I would object during a closing argument.
Well, it looks impolite. Jurors don't like it, so you pick your spots. I mean, there were 2 points I thought Rebecca pushed the envelope. One, clearly Nick objected, and you have to if your opponent is putting up things that were not in evidence. Now, interestingly, there probably would have been evidence of that in this trial, because it would be relevant if this product was used all over the country, and it seemed to be perfectly safe everywhere but here. That's, is that possible? Yes, but it's not very plausible. But it wasn't in this trial, so that was a proper objection. The other point where you were sort of testifying, because I don't think there was evidence in the trial about your growing up at a farm, and you've seen, cows die
By the way,
all
this
the time.
is
all right?
accurate. I did spend
I'm
every
sure-
summer in a farm. Yeah.
I'm sure it was accurate, but I guarantee you weren't testifying at the trial talking about your experience and that cows die all the time. And Nick could have objected to that, but
That would have been, I think, a big mistake if he had objected.
exactly, that would have looked, impolite, because clearly the jury wasn't gonna base this on whether you grew up in a farm or not. But technically you were putting in your testimony and experience, but Nick didn't object to that, because it would have just looked bang.
And another thing about closings, we didn't say this yesterday, but I don't think you're gonna win the case in closing. If I haven't convinced these folks by closing argument, if they're not voting for me, or at least the leaders or a good portion aren't voting for me, I'm not gonna do something in closing argument where they're gonna all of a sudden be like, oh gosh, I've changed my mind. I mean, you've all already had the opening presentation. My goal is to win the case in opening. I get to go first, I'm gonna win it right there. That's when I think I have the best chance of winning the case, is in opening statement. Closing argument, and this process just didn't lend itself, and Rebecca said the same thing, I think, but I really want to try to arm jurors who are with me. If they're already with me, I want to give them what they need so they can go back and explain it to others or fight for me in the room. And something I didn't do, which I should have done to demonstrate it, is just one example, one vignette, to say, what if somebody back there says, how can we be certain there's no testing? I just can't be 100%. And I would say to the other jurors, you remind that person, that's not the law. You can have all the doubts you want, as long as it's more likely than not. So if somebody back there says, well, I'm just not certain, that's the standard they want to use. Judges hate it when I do this. I say, one of you has to go tell the judge, because that is not the law. You're trying to arm your jurors who are for you, and you're kind of trying to put the fear of God in the jurors who are against you that says, don't do that or the judge is going to come and beat you up.
Yeah, preponderance, I've seen lawyers do it. It's just like on a teeter-totter, just enough to push it one way or another. It's not the other reason
feather.
to go.
And I should have done that in this case, because there is no, I should have done that. You can have all the doubts you want, but as long as it's more likely than not that this was tetro, we win. Because I think she capitalized on that. How do we know? How can you be certain? This guy wants $2 million and you're not even certain? Yeah, Mike.
Hey, thanks, Nick. I have a comment and then a question. My comment is, I thought you did a fantastic job in
I
illustrating.
didn't do anything.
Closing argument looks like, well, Your Honor, I gotta suck up to you,
You're still on the bench, I'm still practicing.
But you did, you did, and I thought your ruling on Nick's objection was the right one. But here's the thing for the law students in the room. You both are pros. You made it look easy. And I'm going to steal a line that Steve Miller, my friend, seated right over there, used last go around when I was in one of your seats. And that is, you made it look easy. I know, Nick, you protested yesterday that you're not really thinking about your closing argument until the night before. I called malarkey on that. I think you're thinking about it well in advance. You may not be scripting it in your head, but you're thinking about it. It's obvious, and I think the teaching point. I think my fellow instructor Kennedy, he was here yesterday. I don't think he's here today. I'm stealing his line. Talked about a Drew Brees level of preparation the last time, and for the students in the room, I couldn't agree more with that. This is another illustration of that. You saw two people get up here and make it look easy, and yet it was obvious that both of them engaged in a Drew Brees level of preparation. So I thank you for that, and that came through loud and clear. Here's my question, and you can tell by the gray hair that I'm old school. When I learned how to try a case, there was this important linkage, and I don't remember whether it was in McElhaney's trial notebook or in Mowat trial techniques or watching people like Steve Kaufman try cases, but there was this idea that you gave the jury certain assurances in your opening, and then you linked it up by saying to the jury, look, what I delivered to you in opening statement were the promises, and what I delivered to you in the end was the proof, the facts that I told you would be there, were there, and you now know that. That linkage, I get that the pendulum seemingly has swung. It's been a while since I've given a closing argument that incorporated. But do you find that to be true too? I mean, that used to be kind of a fundamental. I mean, if you took trial tactics at I think any law school in America, that was something that was taught, and yet it seems to have gone by the wayside largely. I wasn't surprised that neither of you did it. I came in here this morning expecting that neither, and I'd already seen yours, that neither of you would do it, but I planned to ask that question. Like, is that just a gone sort of thing in terms of trial practice?
I don't think it's gone. I mean, I almost always start an opening with the evidence will show, and it's usually three things, always three things. But I think part of it was just I didn't give the opening, and so I couldn't double down on the promises. I don't know that it's always like one for one, now I'm going to deliver on that. I think I would view it more from a cautionary tale of you better be darn sure that whatever you say in opening, you can back up by the time you get to closing. Because if there's any disconnect, the other side is going to unveil that. And so I think it's more like be real sure that and that is really, especially in a long trial, that's really sometimes hard to do, and we kind of constantly remind ourselves, oh, we said we're going to do this. Do we have it in evidence? Because sometimes you forget. And if you forget to put something in evidence, they're going to say, she told you, you heard from her, she told you she was going to show this, and she didn't. So I think it's still there. I don't know if it's as explicit always.
My approach is to show the story in open. I don't want to advocate. I'm very disciplined about not advocating. You see some great lawyers and stand up and say, this is a case about profits over safety. That's you are planting a flag very early. Some people are going to be like, no, don't tell me what this case is about yet. So I just want to show the story open. I want to establish some basic fundamental rules that I think I can prove. I think opening statement is harder for the defense because they do have to respond to what I do. I've had months to prepare. Unlike my closing arguments, I prepare my openings for months, and it's a very well put together thing. And the defense has to respond. And I think it's harder for the defense to not make those. I want to try to goad the defense into making some big promises to try to respond to my compelling story where I'm not advocating, but clear conclusions are starting to filter up. Well, we know why they must have done that. And it caused the defense to stand up and make those promises. I get the transcript of the opening as soon as it's available, and I find the things where I think they might have overstepped, and I remind the jury throughout the whole trial, we heard from counsel that XYZ, is that true, doctor? And that can be devastating. So I think you can make more mistakes in opening than you can benefit your case. And another thing I would say, Mike, by the time you get to closing argument, there are times where you think like, gosh, does anybody remember what happened in this case? It's so far removed. But I do believe that the receipts I show in open, I need to be able to pay them and still have them in my pocket during close, for sure. So that's kind of my approach.
I agree. It's more like in the negative that if you overpromise, the other side comes you at close.
Judge Fulcher, can you just quickly comment on Nick's observation that, which I happen to agree with, that he's probably not going to win the case in closing argument? Like, and if you agree with that, when do you think the plaintiff either has the case won or not?
I would agree that the plaintiff is not going to win, but the defense might, or at least tame the jury. Because, Nick, if you haven't convinced a good number of jurors over the course of the trial that you've got the evidence to meet your burden, you can do a brilliant closing and it's not going to do it. But the defense's job is not so much to convince people, but to create some doubt and uncertainty. And I think a good defense closing can certainly persuade a couple of jurors who are sort of in the middle that the plaintiff hasn't made the case, all right? And so we're going to vote for the defense. So I think the defense can probably do more persuading with an effective closing because they don't have to prove anything. They just have to create some uncertainty in at least one or two people who are strong enough to hang in there. And that's really what you're talking about. To not just have the doubt, but even if a majority are for the plaintiff to just say, look, I'm sorry, I'm not convinced. And I'm not convinced enough that I'll hang the jury rather than going. I think the defense can probably, if it's a real, now again, it's got to be based on the evidence, Mike. You can't make stuff up, but you can say it in a compelling way to get someone to say, I'm really just not sure of this.
How would your approach change for a bench trial?
I'm sorry, you did ask me that on a bench trial. I've only tried a couple of bench trials. It's a very different experience. The judge.
I don't like them. I don't like to be the deciding factor.
The judge really gets to dictate how things go because the judge can speak his or her mind. There's no jury or anything, and so I have tried some bench trials. The Court of Claims of Ohio, where we bring claims against the state of Ohio, are only bench trials. We call it the Court of No Claims for a reason. I've tried some cases down there. It's a cool place to try a case. It's in the same building as the Ohio Supreme Court. It's weird being in a courtroom judge with no jury box.
Right.
It's
a
totally different thing. So, when you speak to your audience, it's not different from a jury trial.
It's like an evidentiary hearing.
Yeah.
On a motion to suppress or something, both sides put in their evidence.
You try to learn as much as you can about the judge and see how that judge, how he or her would take in your arguments and evidence, and you by and large do the same thing. Some of the themes that you're trying to capitalize on with a juror, you're not gonna use with a judge. So I think a bench trial is just something totally different than a jury trial.
And the trial itself would be different. I am very, very reluctant to ask a question during the jury trial because I know the jurors are focusing on me, and if I ask a question, they will attach outsized importance to my question and the answer. And so I don't want to do it. In a bench trial, I ask questions all the time. I'm not worried about what's meaningless. I'm going to have to decide it, and I want to know as much as I can from this witness, and if I'm not getting it from the lawyer's questions, I'll ask the ones that are important to me, and I'm not bashful. I say it with an evidentiary hearing, a suppression motion. So it's totally different, but
The advocacy style is different too. Both Nick and I were kind of theatrical here.
Right,
The judge is going to roll his eyes at the chain of speculation. Come on, it's just the facts, man. So it's entirely different.
You asked a question about pushing the envelope, and I'll share a quick story. In a trial once, I said something during a closing argument that was objectionable, and the objection was sustained, and I had gotten a little, somebody said stream of consciousness, I had gotten a little out over my skis and said something that was objectionable, and it was sustained, and it could have been interpreted as kind of impugning. And the objection was sustained, and I just immediately said, I apologize. And I said it to my opposing counsel, and a juror was sitting in the box with his arms folded. He goes, "You should." And, I can't describe the feeling I had inside my body in that moment on my feet, but it was horrible. I sat down after, and the whole room was ringing still, And then the next day, the jury was out with the case, and I was carrying in the exhibits to give back to the chambers. And the judge had all the jurors lined up, and the judge was instructing, carry the exhibits. So I'm like, I gotta walk past all these people, and the guy who barked at me in the courtroom, he goes, "Good morning." It made me feel a little bit better, and the verdict did go our way, but a juror admonished me. And a juror admonished me in front of everyone in the courtroom.
Yes.
And he was right to do it. And
Especially.
it was a terrifying experience. So you want to be very, very careful that you're not pushing me out. Yeah.
When that happened, what was the result?
It was a plaintiff's verdict, and he voted our way, which again was a good experience for me because these jurors, they're like judges. They're trying to get it right. They want to do what they believe is right. And one gaffe by a lawyer, you would hope the jurors don't hold that against the lawyer or the client. And I think, in that case, he didn't like what I had done, but he didn't hold it against me.
Oh, yes. Sorry. This is a bit outside the scope of today's topic, but in a case where if you have a hung jury, would the next move for the plaintiff be an attempt to seek a settlement, since the defense might have a better chance at trial?
I mean, yeah, if you can get a settlement that's in the best interest of your client, you always do that. But what I would do is I wouldn't reach out to the other side. I'd try to project that we were thrilled with the result. We know exactly how to win this case now, and the jurors got it. And now we're going to win the second one and hope that the phone rings and they call me and say, well, we think we're going to win the next one. What do you think? And that's how settlement negotiations start. So it's complicated in any given case how that's going to impact settlement. The one thing is the system moves slowly. So a hung jury, there's going to be post-trial motion practice. There's still a long way to go. I prepare my clients for that. One, we're going to respect what the jury does. We're going to thank them however they rule. And my clients, even in defense verdicts, my clients are satisfied with the process, which is very reassuring. But then you tell them that when the appellate lawyers get involved, it's a brand new case. They're just getting started. So sometimes the verdict is just the beginning. It could be a long road after a verdict.
Most judges after a hung jury are going to be, if they weren't active before in trying to improve something, certainly will. Just from the research standpoint. Because no one likes the case again. You should try it again.
Yeah, no.
I have two questions. So when you're making your PowerPoints, both of you use the similar formatting where you had the black bar at the top with the white lettering and then you kind of put the stuff underneath it. Is that an actual decision that you guys make?
So I'll speak. Every single thing that you saw was an actual decision, literally, the fonts, the color, the placement, every single thing. That being said, this actually was the first time I used this particular format with this kind of background. Just because I kind of got sick of what I've been using for so long and thought I'll try something new. So we didn't coordinate at all, but in terms of decision, you want to think through everything. We're the same. Anything that the plaintiff has done wrong, that's going to be in red. Anything that we've done good, green or blue. Oranges for something else that's kind of a little bit more neutral. Yeah.
I'm finding more and more our presentations, it's interesting. They're starting to look more and more like apps, icons you would find on your phone. There's a reason why that people that we consult with communicate. And just think about how your home screen on your phone has changed in the past 20 years and how those icons have gotten more and more simple. Almost no corporation has their full name anymore. It's one or two letters. It's a very simple icon. And so that kind of imagery, we obsess over it. We obsess over it. It's all very intentional.
I guess my second thing is I think that one of the more beneficial things that you did in particular was at the end when you actually put the manila folders on. It seemed just very personable, I guess, where you have your handwriting and you just kind of put it there and you're this is what they said, as opposed to the whole graphic. It just seems more, as a plaintiff's attorney, I feel that's more of a...
So I can tell you, and I forgot to bring I have these big white, real thick stock pieces of paper. And throughout the trial, I keep them on my desk. and I write stuff. So if an expert just went and it's my turn to cross, or I'm doing a redirect, I'm writing down some things, and then when I stand up, I put it under, I go, now let's talk about this, because this is what we just heard. And when done effectively, when the jury starts seeing me write, it's like triggering them, like, ooh, we're gonna hear about that. And it kind of brings almost the attention back to me. Like when I go to my pad and start writing, the jury's expecting that I've got something to say about that. And I found it can be an effective technique, and it brings us all together. The judge told you about his experience with Mark Lanier, who's kind of pioneered this real-time demonstrative. And I've adopted some of those techniques, and you have to practice, you have to do it. I'm not artistic, and you can fall on your face. But there's something about creating something live with the jury that creates a moment. They were in the room with you when it was created, and they remember it. Do we create stuff and bring it in and show it on the screen? Yeah. But when the jury's actually present, when you're creating it all together live, I think it's much more memorable for the jury if you can do it well.
I was gonna tell you a practice tip. So I agree, and especially on cross, building a demonstrative, so it's their words, and you're just writing their words, and then you hang them with it later. But one thing, so if you're gonna write, I wrote this ahead of time, but if you're gonna write on the fly like he did, you gotta practice your handwriting. And one thing I learned is writing where each thing is one stroke helps you stay neat. Also, if you're gonna write something like this live, which you do, you always wanna have one of these and a pencil, and you create shadow marks, so the jury can't see it, but so that you're not, because otherwise you look at lawyers' demonstratives and it's like half all over the place. So all of these things you have to think out. None of it's just like, oh, on the fly I wrote something. I can assure you whatever he's writing, he's thought about, and he's made sure that his penmanship is decent.
Great.
So with this kind of case, you know, ultimately it's personal property with a finite, you know, range of damages. You can only get up to your, I think it was 1.75 million or whatever it was. And, you know, obviously this kind of case is going to cost a lot to try because it's going to be very expert heavy. It's going to, you know, just cost a lot of money. Would either one of you actually push to try this kind of case in real life, or would this be one of those cases that you're pushing to settle?
Well, I had actually mentioned the problem doesn't really give you a number of damages, and so in the lead up to this, Rebecca and I and the judge, we were emailing like, we have to make it some number where it makes sense. You know, I actually looked up, like how much would it cost to replace 40 cattle, and it was like, it could cost as much as $200,000, and it was like, well, we're not going to try this case over $200,000. So, but I would say in my practice, as a single event case, $1.75 million would be a case that would be worth taking on and trying for sure. That's a significant case, but you do get into cases where you have to manage them differently to make them cost effective. And there are some cases that Ohio has caps on some damages. There are some cases I just tell my clients, like the caps just, this case can't make sense. It's going to cost too much money, and no matter what the jury says, the judge has to reduce it to the cap amount. So that's a constant decision on both, certainly on the plaintiff's side. This would have been a case that would have been worthwhile to try at that amount.
And also, what you have to think on the defense side is it precedent setting? So even though my slide got dinged, you know, we have wells all over the place. So this may not be a lot of money for this particular case, but we get a bad verdict, they're going to be crowing and getting plaintiffs all over the country, and so it's worth actually more than that.
That makes sense. You gotta defend your product, because if you concede or you lose, it's a lot of repercussions.
I inject with just one comment. I think in fairness, if it really went the plainest way and these contaminants were introduced into the Columbia stream by your client, this would be good news for your law firm. I think this would be a class action case. It wouldn't just be Mr. McNamara who'd be complaining. about it, it would be many property owners in need of either joining together. It might be a mass action, it might be a class action, but I doubt it would just be the McNamara farm coming after.
Well,
if it wasn't before, it would be the day after.
Yeah, it wouldn't if it wasn't a fair point, Steve. Then they'd hire
if
Nick
there were a lot
and
of
his firm to
farms-
represent them.
If there were a lot of farms, right, but and if there were, and the only cows that had a problem were McNamara's, that plays in the defense that he's the one causing the problem with his cows. Right? If everyone's drinking from the same stream, and it's only his cows are sick, well, it's probably not the stream.
I agree with you, Your Honor. I mean, isn't that like from the defense perspective? Isn't that one of the most imponderable facts, right? That if they're all drinking, if all the cows are drinking from the same stream, why didn't they all get sick?
You know, if I was ready
It's a
for her to
huge
say
issue.
that, and she didn't, and I thought of what I was going to say and reply. I was going to say, I was going to try to capitalize on like the big tobacco lie that we heard, and she was probably smart not to do that because I had something, and she said, you know, what about the other 100 cows on his property that drank from the stream? I had a little vignette I was going to do about, you know, smoking causes cancer, but not everybody who smokes dies. I mean, are we getting the big tobacco line in this case? So maybe it was smart not to go there, but I agree that was a good fact. But that kind of analogy, to the extent you could do it either with an expert or something, is how I would tackle something like that. We all know that smoking causes cancer, but that doesn't mean everybody who smokes is going to get it. And that was kind of a big tobacco defense for a while. Why isn't everybody getting cancer? And that could really land with some people. Larry, did you have something to that?
I did, and it's something in response to what you said, Nick, that it's a $1.75 million case, not a $200,000 case. But I think, as Steve said yesterday, to the younger lawyers, if you don't start on a case, you'll never try a case. So if you get a case where you're looking at $50,000 potential, $100,000 potential, try the case. What's the downside? You learn something. You have to pay your dues. You have to get the experience. And then once you get to be at the level of Nick, then you'll be getting the $1.75 million cases. But you have to start somewhere.
That's a great point. There's some great trial lawyers who are trying those kinds of cases because they're just always in court trying.
Right.
They're doing a great job. Steve?
So, in the course of any trial, jury trial, jurors some of them are just going to be poker faced. Some of them are going to react little ways, big ways, body language, eyes, whatever it is. Could be during witnesses, could be during an argument, could be anything. So I assume you pay attention to those things in the course of a trial. Somebody's like paying attention, like which jurors are doing what. So when you get to closing, knowing what you know about certain jurors reacting to certain things, witnesses, whatever, does that affect anything you say in the closing about particular jurors that you may want but will react negatively or positively?
So actually we were talking last night about AI. I'm very excited about AI. I can go on and on about it. I think it has tremendous opportunity for the law and trial lawyers. And we were talking about how now we load in everything we know about the jurors and the transcript and what's happening and like what they might. I would just caution, and I learned this both from talking to jurors after verdicts and from seeing them in mock exercises. The jurors that you think might be going one way often aren't. Like you're just reading them wrong. And so I think do that at your peril a little bit. And some of the ones who sat there looking like they hate you later are like, oh my gosh, you're so great, love your shoes. So I just think you've got to be really careful with that.
I agree. You have to be careful. One thing I've learned when I babysat the jurors, I found that the person who was most likely to be the floor person is the person who picked up the instructions first, never sitting on the table. That was it. I've also learned after trying a lot of cases who are going to be the leaders on the jury, and I'll share this. Maybe I shouldn't. But a lot of their time is spent on the only things they get to decide is, how long do they want their lunch today? The judge will usually either say, we're going to take an hour. I was thinking of I have a matter I need to attend to, do you want to go to lunch now or should we do the next witness? Watch the jury. because over the course of the trial, when they're asked a question like that, they'll tend to start looking down the row at the person who's making that. I think that's the biggest tell as to who the leaders on the jury are. Day 4, day 5, and the judge says, "Do you want to take a lunch break now?" And everybody kind of, their eyes are over 1 or 2 people, and they kind of nod. Like those kind of things. I mean, yeah, you need to be watching them, and you need to be doing it in a way where you're not, staring at them like this.
I don't tend to like that.
And today I struggled. Yesterday I was better. Today I struggled because I didn't have my people. Like I was a little nervous today because I couldn't connect with anybody. It's hard in here. You don't have the jurors in the box to connect to, and I kept looking at my jurors. My jurors walked out on me today.
That one's on
They
us.
abandoned.
Feel good.
I heard Mark Lanier's name dropped a few times, and he came here last semester for a great talk.
I think you heard him dropped a few times by the plaintiff lawyers, just to be fair. Just saying.
I was impressed when he came.
No, he's very impressive. Yeah.
But he said something that stuck with me, and I wanted your guys' opinion on this. He said, read Aristotle's rhetoric cover to cover multiple times. Would you agree, disagree? Would you say it's kind of irrelevant? It's a person-to-person basis? Like, should I invest in rhetoric and read through it this summer?
Well, he's at what you may not know this about Mark, but he's a theologian.
Right, he's a biblical scholar.
He's a biblical scholar.
He's a full-time preacher.
Yeah.
In the middle of trials, he flies home and he preaches to a megachurch every Sunday morning. And he has a collection of biblical art and artifacts.
Yeah, he's got a library. So I think for him, that's something that he's very interested in. He's not just picking up the book because he thinks it's going to help. In this case, he's doing it because I couldn't tell you. I haven't read that book. I wouldn't be able to comment one way or the other on.
I say sure. there's a lot of good stuff out there. And look, I mean, I don't think you can go wrong with advice from Mark Lanier. Right.
Both of you have mentioned putting juror and for just things about the jury into AI, and I wonder if there's any ethical concerns with doing that.
You're putting things that are
broad, public and broad, but I think right now we're being taught a lot about AI, and so when I just hear even broad things about putting through the jury and AI, even I get a little
I mean, well, first of all, I don't know. I don't have ethical concerns in the sense of. It also depends. We're using a closed system, so we're not putting it out there and saying, okay, the rest of the world learn from the information I'm getting. So it's a jury. And I think there's going to be more and more rules about what the judge saying you can use or you can't use. The fact of the matter is that we've been doing research about jurors for decades. Facebook, then Instagram, then all of that. Now, to me, AI is just making it much more efficient. And it goes to what you have a reasonable expectation of privacy about. But it's a very interesting question, and I think with AI in general, I'm excited about it. There are ethical issues that we all have to think about.
Yeah.
Okay. A couple observations, Rebecca. I don't know if this is in the facts or not, but one causal link that didn't exist or wasn't talked about is how does whatever was in the pit get to the stream, other than by inference? No direct evidence.
Yeah, I didn't have anything good to the contrary. I mean, I think it's kind of a reasonable.
I don't know. Because
okay, no, fair. It's
the
just
point is it has to get somehow, some way. And for example, if you were going to bring this case, somebody had to look at that pit. Mm-hmm. So that might just simply an issue in the fact pattern. Talking about the differences between trying to a jury and trying to the bench, it's a big, huge difference. One, you assume that the intellectual level of the court, or if you're trying to a single arbitrator, same thing, is much higher than you would have to do to a jury. So your teaching aspects of the case are completely different. I've sat as an arbitrator on tons of cases as a single arbitrator. And I like to ask questions. I don't like to be bound simply by the lawyer's version of what they think is important. But I think it's also a problem that as soon as you ask a question, all of a sudden the lawyers start focusing on the question and the presentation gets much narrower than what it should be. So I've had to like ask questions that I really don't care what the answer is. Okay? But I also understand that this is highly artificial. You know, you didn't do the opening. You didn't take any of the witnesses. You didn't introduce any of the documents. And so you're here trying to summarize what everybody else has done or should have done. So I know it's hardly artificial, but I got to tell you, this was an incredible presentation. You guys are very good.
Oh, thank you. Thank you very
Doing
much.
what you do. You know, the structure of your closings really good and very sharp. You know, your use of analogy was spot on. You know, I was looking for something similar. You know, particularly on what is reasonable care.
So you know what's really interesting, and we might be wrong. I say my firm and kind of the trial lawyers, we are very allergic to analogy. And the reason we're so allergic to analogy is because a good plaintiff lawyer will stick it to you. And so when we do use analogy, we think about it for weeks, maybe more, and more often than not, we throw it out. Because it's such, I mean, I don't know. I've just seen defense lawyers more often than not step into it. So I hear you. I love an analogy, and to teach, it's almost the best way. But I've just seen so many people get burned. But it could be wrong. I'm not saying like I want to learn. It might be wrong, but that's just why I didn't use an analogy.
So Rebecca mentioned AI. She's very excited about it. I'm stunned by its power. Could each of you comment on to what extent you would use AI?
We had a good discussion with some of the students last night, Rebecca and I, about their perspectives on AI. And my takeaway is, I think if you start off with, I want AI to accomplish the end task, you're down the wrong path. I feel like if you want to use AI to help in your process that you're dictating, you can't kind of go wrong. When somebody was asking me kind of the most direct and aggressive use of AI at trial is, in the cases Rebecca and I try, we're getting daily transcripts. They cost a tremendous amount of money, and we pay to get those transcripts. We're going to use it. We have a closed system. The whole case is loaded into. We have all this information about the jurors loaded in. And you can get to the point where you can just start asking AI, what's the best argument to convey to juror number one? You can do that. It's there for the taking. So that's at one end of the spectrum. The other end of the spectrum, I'll ask it, give me a good rule of three. Here's the facts. I'm a plaintiff's lawyer. Give me a good rule of three. We talked about the sophistication level of your audience. I mean, we're trying this case to very, very sophisticated, intelligent people here in a law school. Our jurors are going to look nothing like those of us. Nothing. And their reading level is going to be, if we look at the data, something around 7th to 8th to maybe 9th grade. And so I'll often ask AI, explain this to me like I was an 8th grader. So it'll give you some great analogies. It'll give you some really good ways to communicate. So that's how I'm interacting with it and using it on a day-to-day basis. But if I were to say, draft my final argument, I might draft one, but for all the reasons Rebecca and I told you, it won't feel great coming from your mouth because you didn't create it. Now, if I used AI to help me come up with a better way to explain this part of my close, then yeah, I think it's got tremendous potential.
Everything that Nick said, it's garbage in, garbage out. What I highly recommend to folks is to learn something called Markdown. It's a very simple, that's how AI thinks and talks. It doesn't actually talk in natural language, it talks in something called Markdown, which is very easy. So it's only as good as the prompts that you give it. I agree, it's not going to do the end result, but for instance on graphics, I haven't yet seen an AI tool that can create the kind of graphics that I ultimately want at trial, but it can create really great ideas that then I work with our graphics people and I say, okay, and those before would have taken me, on a path, like, okay, I'm thinking this and this. Now you have a starting point that's just better than the starting point you had before. For oral advocacy, we recently did an experiment where we had a summary judgment that had already happened in front of a judge, and we knew the outcome and we knew how the argument went. We wanted to see whether you can practice using AI. So we uploaded all the other transcripts we had from that judge from oral argument, all of the briefing and everything, and we had very detailed instructions of what we wanted to do, and we ended up with a real-time argument. And it was fascinating. The judge was just as persnickety as that judge is in real life. The points that the judge made were exactly, we didn't load the actual hearing from the summary judgment. We were trying to see whether it would get it pretty right, and the judge did. So I just think there's so much power that we're gonna see. But again, it takes folks learning how to use it. It's not as simple as opening Claude or opening Harvey. And for you young folks, like, you are gonna be such a value add if you know how to use it. I have gray hair and I'm learning how to use it, but not everybody in my vintage is. And so be the ones who know how to use it. It's tremendous.
I was in trial and I had this expert, infectious disease doctor, and we had over 800, some plaintiffs' lawyers had shared a repository, and we had over 800 depositions. I loaded them into AI and I started conducting cross-examination and told it to answer based on what this witness was likely to say. And there were parts of doing that process that I used in my cross, and it went well. So think of that. Cross of the witness in the witness's own words based on several thousand pages of questions and answers to that witness. Yeah.
You were tying you a little bit more, tied your arguments back to the law. Given that the jurors might not always be the most apt at, like, as you said, reading more like an 8th or 9th grade level, what is your theory kind of about how much you put in, what you kind of highlight? Like, it seemed like you didn't put that much in, but you put enough in to kind of tie everything back.
Oh, you mean the law? Put it into the law? Yeah. I mean, in closing, you're always using the verdict form. You might be using the jury instructions. I mean, this is where I made a snide comment yesterday, but sometimes trial lawyers don't focus on that, right? Like, he's hoping his narrative carries. I'm hoping my narrative carries. I don't know about Aristotle, but I will recommend Pixar and The Moth. We were talking about The Moth. Reading about how to tell a story, because that's what trial lawyers are, basically, are storytellers. And so sometimes the storytellers kind of ignore the law. But for the defense, the law is really, well, it depends. If the jury instructions are good, we'll focus on the law. If they're not so good for us, we focus on it less.
So we shouldn't sit in this historic room and spend 2 sessions talking about closing argument without taking a moment to talk about theory of the case and themes. So I'll say a couple things, I'll ask a couple things, and I'm really interested in your comments. The thing I'll say first is that there were clear themes that were used, each of you had focused on. I think a question is, were there themes that you considered and tossed out? I know you may not have spent as much time on the mock as you would on a real case, but powerful use of chain of speculation here. Powerful use on Matt Barron of that's a man with a mission and a grudge. These are specific themes that you designed. This is intentional. This does not happen impulsively on the courtroom floor. You took her theme, chain of speculation, and went straight at it. You took it and sought to flip it and make it your use of her theme. So I'm fascinated by what your theme preparation was and if there were things that you abandoned coming in. You also went straight on the Tetro is safe, Tetro is dangerous. And were there big theory of the case questions that you wrestled with on this? What did you discard rather than use?
I didn't I more was just nervous about things. To be honest, we didn't have testing, so I had to figure out how do I come up with a theme that doesn't look like I'm ignoring the bad things, and that goes after him, but goes after him in a way that doesn't get everybody mad. So I don't know. I feel like sometimes for the defense, you're more walking a tightrope. Now, hopefully, in a case that I've worked up, our evidence is more robust, and and I have more affirmative things to say. But to have the theme, I actually think it's a pretty weak theme. That it's my theme was basically like he hasn't carried the day. As much as the plaintiffs have the burden of proof, the fact of the matter is that the jury is looking for the defense to prove their side too. I know that. So this one was where I was more like relying on, he has to do his thing. But in a trial with hopefully more robust evidence on my side, there would be more affirmative themes of like, I wouldn't say we have to prove it, but I would give the jury the picture that we've done our job here and in a more affirmative way.
On the plaintiff side, the themes that I'm trying to look for and tease out are the same in any case. I want the jurors to think that's wrong. That's wrong. It doesn't matter whether you're a Republican or a Democrat or older or younger, and so there are things, a violation of trust, a lie. There are just certain fundamental things that people say that's wrong. And when you talk about following the law, and we know jurors do their best to follow the law, but if they believe in their heart that that's wrong, they're going to, when that law is read to them, they're going to receive that law through a story and a perspective of this was wrong. And so I'm trying to capitalize on themes that speak to that. Thinking the jurors, this isn't like, so when you're talking about I'm running with the wind at my back. We have a petroleum corporation, it's just right there. Social responsibility, truth, honesty. Those are the kind of things you want to find, a violation of trust, a lie, danger, right? If you can find those, and as a plaintiff's lawyer, if I can find those things, so I do a lot of medical negligence cases, I put my clients on the stand, why did you go to this doctor? I trusted him. That's powerful. So I wouldn't come out and say that, but if you can start feeling like this woman trusted this man, and he never looked at me, that's a violation of trust, and that thing will carry through. One other thing, and we didn't have the benefit, but I will always do on the plaintiff side, you're pointing the finger, and Rebecca did a very good job of kind of, this guy's pointing the finger at us, and he hasn't done X, and he hasn't done Y, and it's our fault, right? That's powerful. She did that well. I make it a point to put my plaintiff on the stand at some point and find something to make my client take full responsibility for doing it. Failure, refusal to take responsibility is a big deal. And so I'll find something in the record where my client didn't follow up with the doctor, and I'll cross-examine her on the stand and say, ma'am, it says right here, you know how to call the doctor, don't you? Did you do that? No, I didn't. You taking responsibility for that today? I am. You could have, you didn't, did you? No. Okay. Then when the defense lawyer gets up and says, you didn't call the doctor, and the jury's looking at the defense lawyer. I want to be in a situation where we're taking full responsibility, and in this case, there would have been opportunities with McNamara to try to do that. I tried to do it, but just didn't have much substance. But I would have put McNamara on the stand and say, there was this documentary, and this is, tell me, sir, could you have done better? Yeah, could have. There's allegations of abuse of these animals. Are you taking responsibility for that? I have to. It's my farm. Now let's look over the other side. We didn't do anything wrong. Tetra's safe. Nothing we can do. Those themes are nice. Taking responsibility is a big one. I try to take responsibility, and I try to look at the other side, and they're refusing to do it.
Judge Polster, you hear more advocates than the rest of us put together. What are your thoughts on theories and themes?
I'm a big proponent of them, Steve. I was a lawyer. You want to have one or two themes, and you introduce them in the opening, and you focus on them in either the direct or the cross, and you come back to them. again, that's part of telling the story and putting a framework, all these facts into a framework or a theory. Responsibility, honesty. I think most people, everyone knows to make mistakes, all right? But when you make one, are you honest enough to admit it and try to correct it, all right? And if you are, then they'll cut you some slack. And if you're not, you get hammered. And and if you can, pound away at that, as a plaintiff, you're likely to win the case, even if that's not an element of the claim, all right? Because if you can say that this defendant corporation, they didn't treat people honest and open, you can win. And even a discrimination case, all right, we got all these complex instructions about burden shifting and all this crap, and sometimes I think the jurors might throw it out the window and go thumbs up or thumbs down. Did the defendant treat this employee fairly or not? All right, and yes or no. So again, that's I'm a big proponent of that.
Nick, you did something subtle but profound. I don't know if you heard Eric Kennedy speak about his openings and how he pounds away at trustworthiness and telling the truth. And if they're being candid with the jury and if they're being candid with the world, you took it one really interesting psychological step, which is to say to the jurors rhetorically, think about, are they being truthful with themselves? That was a very interesting, powerful theme.
Right, because the evidence would have been, and there was a lot more in there, there's only so much we could do, but the evidence would have been, they rushed this to market. Why? Well, it might have saved the company. There was a lot of money involved. And sometimes, if M.K. Phelps looked really good on the stand, you want to be able to tell the jury, look, we can understand. You can understand you have this opportunity to make a lot of money. We've been there. Maybe you would cut a corner. And that's why they are here in this courtroom, because you need to make this decision. Maybe they just can't do it. And it's human nature. We understand that. That's why we need juries to rein things in. So I tried to capitalize on that a little bit.
I just want to. I think we're about to get the hook.
No. I'm going to try to incite both of you.
Oh, okay. But I do want to take this opportunity to raise two things which are kind of near and dear to my heart. One, this job is hard. Whether you're a trial lawyer, whether you go out into corporate law, public interest, not public interest, this job is hard and it's stressful. And that takes a toll. And so what is really important is that you all make sure that you take care of your mental health. And that means if you need to reach out and get help and go to a therapist, go to a therapist. Make sure you have friends. Make sure you have your support system because you're going to need it. And that also means trying to hydrate and do all those good things. But I can tell you from the best, all of the best lawyers have faced incredible stress and have needed help in some form or another. And so, I want to put a plug for let's be open about that and do those things. And then the other thing I will say is I'm not the best lawyer by any means, but I steal ideas. So steal ideas from Mark Lanier, steal ideas from Nick DiCello, ask mentors, ask people, have people read your exams and your work and give you ideas. Because again, it's the best ideas come from all places, and don't just sit in your office and think that the weight of the world is on your back.
I know everybody's got schedules, that's why I stood up.
Yeah.
But that was a really great way to end it. I'll tell you,